I'm just going to wait a couple of minutes as people start to dial in. So as you start dialing in and hear this conversation, I'm just filling the air at this present point. I just want to give it a couple of minutes to get as many people in as possible, and welcome you to this Equity Trustees update on regulatory changes and so forth. So I'll start the conversation and see how we go. So my name's Harvey Kalman. I'm the Executive General Manager of Corporate Trust Services at Equity Trustees, and we're producing this webinar effectively to give our managers and service providers and partners the opportunity of understanding the regulatory change and the vexed nature of the regulatory change. So this morning I've asked Nikki Bentley from Ernst Young, Financial Services Law Partner, to present a presentation on the new licensing regime for fund managers. Now, again, this webinar will go relatively simply. Those of you who may have seen the email that we sent out with Nikki's presentation, there will be an update on that and also the highlights from that presentation. And once Nikki's finished that presentation, there is a Q&A button down the bottom of your screen. Please start putting through your questions in relation to the Q&A. So you can put them through at any point, and then I will sort through those, ask Nikki the probing questions, and we'll get some great answers. So without further ado, if I can enthusiastically welcome Nikki Bentley to this webinar. And Nikki, as discussed, if you'd like to talk about the new licensing framework from ASIC, I'd be very, very happy for you to take over the microphone.
Thanks, Harvey, and hello, everyone. I'll just start with a very brief recap on the changes to the licensing regime so that we have plenty of time for Q&A for most of the session. So for those of you who are currently carrying on financial services business in Australia, you'll be aware that you need to either be licensed or have an exemption. Many foreign fund managers rely on two existing relief. One we know as the sufficient equivalence relief and one as the limited connection relief. For those managers relying on those relief, you have the benefit of a 2-year transition period before the new licensing regime commences. In short, the new licensing regime has two key elements. There is a very limited funds management relief that will continue on and will require lodgement of some documents with ASIC, as was the case with the sufficient equivalence relief. But the scope of the activities that you can provide under that relief is very limited, and it only captures your inducing activity. So encouraging Australian clients to use your financial services is within the scope of the relief. And it's a limited subset of Australian wholesale clients that you can provide that inducing activity to. If you have an existing mandate with an Australian client, or you're the investment manager of an Australian fund, then it's likely that you will need to obtain a foreign Australian financial services licence. If you're from a recognised jurisdiction, then you'll be eligible to apply for the streamlined licence application. And because you're from a jurisdiction that ASIC has recognised as sufficiently equivalent, there will be a number of exemptions that local licensees will comply with that you won't have to comply with because you're regulated in your home jurisdiction. For example, the financial requirements that apply to a local licence will be exempt for foreign licensees. While the process is intended to be streamlined, and there is the 2-year transition period that I mentioned, which expires in March 2022, it does take some time to go through our licensing process, and we're expecting a number of foreign fund managers to need to get the foreign license. So my recommendation is, if you need to get the license, to start that process sooner rather than later, so that you don't get in the bottleneck and risk not having transitioned in enough time for the end of the transition period. If you're a new manager looking to do business in Australia, then unfortunately you don't have the benefit of the sufficient equivalence relief, which has now expired. And therefore, you may need to look at alternative arrangements while you go through the process of getting a foreign license. And that might include being appointed as a corporate authorised rep of a licensee. So that's a very quick snapshot of the new licensing requirements that are coming into play. And I'll hand back to you, Harvey, to hopefully run through some questions.
Terrific. I took myself off mute. First of all, I'd like to sort of say a couple of things. One is that at Equity Trustees, we are looking to help our fund managers during either the transition period or after the transition period by allowing them to leverage off our license using a corporate authorised rep or CAR to help facilitate some of the changes in the environment. But I'd also echo Nikki's your comments that effectively it would be excellent to effectively get to a scenario where everybody's nice and early in the equation, talking to their advisors and consultants to get on top of their licensing regime, because there will be, as we always know, there will always be a bottleneck back, and the regulator only has a limited number of resources to be able to look at this environment. Now, I also, as I said earlier, I encourage people to throw some questions in. One I'll answer very quickly. Yes, I am wearing a full suit and the like, and I did do a quick change to ensure that I was properly represented in this meeting. With the humour aside, if I can start hitting a couple of questions, the first one I'd like to hit was one that was done early, and here it goes. It has been mentioned that these changes aim to dispense with the, until now, light touch approach. What is ASIC aiming to achieve with this regulatory or regime change?
Yeah, so ASIC has been consulting for quite some time on these changes to the licensing regime, and they've done a lot of work around what the regime should look like for foreign financial service providers. They looked at equivalent jurisdictions and found that their existing sufficient equivalence relief was too light touch and compared to other jurisdictions. They also had some issues with, even though it was a very light touch regime and there were minimal conditions to comply with the sufficient equivalence regime, they did struggle when there were concerns raised by providers that weren't compliant. And the regime had that ASIC had to go and talk to your overseas regulator and share information if there was concerns about enforcement. And they found that it was really difficult to get responses from the overseas regulators because they were obviously juggling competing demands. And so one of the changes to the regime is that there's a direct connection between the foreign manager and our regulator. So if ASIC needs to ask for information, then you need to provide that information as either a condition of your license going forward or as a condition under the funds management relief. So that was one of the drivers for the change going forward.
Terrific. And I suppose it was also one of the drivers was that we were giving free passes coming into managers into Australia, but we weren't getting the reverse passes coming back out the country. But again, I think the real high point that you sort of emphasised is this idea that the regulator needs to know what is going on and being able to make people accountable. And that's one of the major drivers of the change. If I go to the next question, do you expect many offshore managers who are currently relying on sufficient equivalent relief passporting to market offshore products to Australia wholesale clients to seek to rely on the funds management exemption?
I think it's very limited in scope, the funds management relief, and it might be suitable if you're a new entrant to the market and testing out the market to see if there's demand for your product. But as I mentioned in the introduction, it only captures that inducing activity. So if you're successful in an Australian investor wanting to invest in your product, then you're going to have to look at different means of being able to service them on an ongoing basis. So whether that's being appointed as a corporate authorised rep or getting your own Australian licence, then I think that's going to be more common. Certainly in discussions with the fund managers that we work with, many of them that have an existing book of business in Australia, recognising that they'll have to transition to the foreign licence.
Terrific. And that does make some sense, in the sense that, you know, if you're coming in and talking to Australian, flying in, flying out, which was obviously something you were doing in the past, but you may not be able to do in the future, or until actually the relief comes off. But if you're flying in, flying out, ASIC still wants to know what you're doing and who you're talking to, and that you are meeting the local requirements. And so that's a very logical extension. I'll go to the next one. Would ASIC be open to allow again, it's in code FFSP, who attains a foreign Australian financial services license, appoints a corporate authorised rep under its foreign licence, where they may have multiple offices around the world?
Yeah, one of the initial suggestions from ASIC around the regime was that a foreign licensee would not be able to appoint a corporate authorised representative outside its corporate group. So they certainly, even from the early initial stages, anticipated that a foreign licensee could appoint a corporate authorised rep within their corporate group. In fact, that restriction limiting it just to the corporate group was removed when the regime was finalised. So a foreign licensee is able to appoint others under its licence. Obviously, they are responsible for those representatives and they need to be able to be supervising them. But it is an option available, particularly to groups where they don't want to have multiple entities getting an Australian licence, and it's a sensible approach to work through. Terrific.
I like this one. Hi, Harvey. Can you walk through how a foreign fund manager might leverage the EQT AFSL, if I understood you correctly? Okay, so relatively simple. Currently, when we sign up a fund manager under an investment management agreement, they become an agent under Australian law of Equity Trustees. So they're leveraging off Equity Trustees' licence to have the product set up in the first place. This would be an extension, by doing a corporate authorised rep, would be an extension of our of that relationship we have with our fund managers, which allows them to do the conversations with the clients without us physically having to be there, but also talk to their clients about mandated funds rather than just the fund itself. So, if you like, it's an extension of what the services we see at Equity Trustees that we can help partner with our fund managers to do, to help them move into a direction where they are talking to their clients, and then we build certain controls and procedures around that. In fact, we did this last year when we had a client who was applying for their license, but because there was a delay at ASIC because they were just under the pump, we did a corporate authorised rep to start off with, you know, for 6 months to 12 months, and they ended up by getting it within 5 months, which was fantastic. I did ring up the fund manager with a strange South African accent. That's the only one I could really do, and tested them to see if they would behave appropriately. They answered all the questions appropriately. I then logged it in as part of our testing procedure, and when I went back to report to them, they didn't realise it was me, but they answered everything appropriately because we gave them scripts, we gave them procedures, and they did everything appropriately. So to that extent, as I said, it is an extension of our process, but I still believe that managers should apply for a form of an AFSL in Australia, and we'll call it the light or international version, because I think that people should show commitment to Australia rather than just sort of a turnkey solution or fly in, fly out. So happy with both solutions. Nikki, did you want to sort of comment on my comments?
Yeah, for sure. I think it's a really great solution, particularly because many foreign fund managers do want to test the market and don't want to incur the costs of getting licensed until they are sure that they're going to get Australian clients and need to be regulated. But then there's that time lag, because ASIC's service charter says that they'll process 75% of applications within 8 months, and often don't meet that service charter because of resourcing needs. And we have 750 managers at the moment relying on the sufficient equivalence relief. So we are likely to see that time frame go out. So I think having the corporate authorised representative arrangement, particularly as an interim, when you decide this is a market, you're successful in securing clients, and then you start the process to get licensed, makes sense. Being a corporate authorised representative does mean you're subject to that supervision and monitoring that Harvey mentioned, because the licensee is responsible for you. And so you do need to go through that process, and so there's a cost that's involved in doing that process as well. So I think certainly the Australian super funds are already starting to ask foreign managers, how they're going to comply with the new licensing regime. So I think it is something that they do validate when you say we're starting the process to get licensed in Australia. It does show that commitment to the market, in my view.
Yeah, no, Nikki, that's a great answer. And this one's come through on a different medium, and it's a similar sort of thing, but it's probably the same answer. Does this mean the death of the fly-in, fly-out offshore managers? And Nikki, I suspect the answer is no, but they will need to go, Nikki.
Yeah, I mean, the Australian licensing regime does get triggered probably earlier than other overseas licensing regimes, in that it does capture inducing people to use your services. So that does capture people outside the jurisdiction trying to get Australian clients, and also the fly-in, fly-out model. I think the sufficient equivalence relief was an option that many managers did and made it very easy for people to come down and fly in, fly out. But that was always intended to be the initial start of someone entering the Australian market. And I think ASIC was more concerned about those that had established a business in Australia, set up a business in Australia, and was still operating under the sufficient equivalence relief. So I guess their sense is that once you certainly have more of a presence in Australia, then you obviously need to be licensed, and there's this light touch license for those doing the fly in, fly out.
Terrific. Thanks for that. I'll jump around a few questions. We are a third-party marketing group with wholesale AFSL. Our fund managers leverage off that AFSL while marketing in Australia. Going forward, do you recommend they also apply for their own licence?
Look, having the third-party marketer that has the license and operating under that is an option. It's a well-trodden path and makes sense to do that. Again, particularly while those managers are building up their book of business in Australia. There is a risk to the managers, because usually those arrangements can be terminated within very short notice frame, and there's obviously a cost that comes with that. So it has to be balanced up against their existing business, what their plans are for Australia, and how that distribution arrangement works.
Yeah, and I would add, Nikki, that in my experience, the key to success in any jurisdiction, including Australia, is having the right distribution model. And if a foreign fund manager, for example, has a good third-party marketing firm that can access the market for them and be there in time zone, and also travel around the country accordingly when the borders open, of course, then that's a very powerful option for foreign fund managers. And again, I wouldn't see necessarily that in that circumstance that a foreign fund manager needed to have their own AFSL, as long as when they come doing the marketing, or when they're doing internet or email marketing, it's done through the AFSL of the wholesale third-party distributor that they have in Australia. That would be a legitimate solution, and one that would apply to the law.
I agree with that.
Terrific. Okay, now I've got a few more questions, but I do encourage you to really hit the questions via the normal mechanism rather than my phone, so that I can actually triage these questions. And we are going to finish in about 10 minutes. So if you've got questions, pump them through. Does it seem likely that ASIC will be flexible for those who don't meet the deadlines because of any bottlenecks that may happen?
I It's hard. I wouldn't be relying on that fact. ASIC they were very flexible when we were coming up to the deadline for the sufficient equivalence relief. So you had to apply and get the benefit of that relief before March this year. And there were a number of managers that came in. ASIC put a lot of resources into that. They turned them around quickly. And then at the last week or so, they said, if you put in your documents and you're waiting for us, particularly because that was during the beginning of the lockdown, so it was difficult to get originals to ASIC. They did have some flexibility, but given they've given a 2-year transition period, and if you put in your application late, then I'm not sure that they will be as sympathetic. And if you've, as I say, if you've got an existing book of business, you don't want to have the risk of not being able to service those clients. And as I've said, we're already seeing the super funds starting to ask the managers that question. So I don't think your clients are going to be very sympathetic to you if you say, you know, we haven't quite got there yet because we're a bit late going in.
Yeah.
Sorry, go Javi. Yeah,
I would completely agree in the sense that there's an expectation that if this is your business, that you have engaged in it and actually taken it seriously, because the super funds, as they did with DDO, they're starting to ask questions. They want to be able to tick that box rather than have it as an outstanding issue. And, you know, we're moving now, I would suggest we're moving almost back to BAU in the way that people are behaving, apart from the fact we're not in the office. And some of the things that were giving us a lot of pressure in the last couple of months are starting to release and relieve, in the sense that we now have opportunities now to do projects that are time critical to set the resourcing and make it work. Now, that leads to the next question. Nikki, based on your familiarity with the application process, how much time and obviously resources do you think firms will need to allow for this process to be successful?
That's a good question. I think there's a bit of lead time before you're ready to make the application. So while a number of Australian requirements you're exempt from, you do need to understand what are the Australian obligations that you'll be subject to once you've got a license, and you'll need to review your policies and procedures and make sure you're at least complying with those minimum levels. Australia it's not a very prescriptive regulatory regime, so it's very principles based. So our experience is that you won't have to do significant amendments to your existing policies and procedures to comply with those obligations, but you'd have to sign declarations when you put in the application that you will be complying. So you need to do that initial assessment of what you'll need to comply with and ensuring you are. So that can take, depending on how much resourcing you've got, you know, a couple of months, 2 to 3 months to get the application ready to go. A lot of the application time is when it's in with ASIC, waiting to get to the top of the pile and get assessed by an ASIC officer. So that can take some, you know, it can be 2 or 3 months once you put the application in before you get it. And then there might be a couple of rounds of requisitions with them asking you information, providing some supplementary documents. So while it's a long time process, and we generally say allow 12 months to go through that process, it's not an resource intensive process to go through, if that makes sense.
It does, and I obviously offer an easier solution in the sense that if you're concerned about this, you can actually do in a lot quicker and a lot cheaper time a corporate authorised rep through Equity Trustees, and we build that model, and in parallel operate and set up your own AFSL, or not do an AFSL depending on what we negotiate with you. And that's the real key, is the fact that we know that most people will leave this till the last minute, but that's one of the reasons why plan A, plan B, or option 1 and 2 is important for managers to allow for. But this is why we're starting the conversation now, because we will know that people will get caught up in other things, and we all get busy. And the reality is that licenses are important for be able to operate in day-to-day operations. And again, international fund managers, you know, there are easy options or easier options, but again, like when you operate in another company, in another country, should I say, you look for the best solution for you depending on how much resourcing you want to put in on the ground. And as I said, the corporate authorised rep may be the best option for you, and we're happy to help with that as well. Now,
I'd just add to that, Harvey, and to say, I know, there's obviously a number of managers that are heading into their summer months, which can traditionally be quieter for the legal and compliance, particularly when you can't travel. And so we've got a couple of managers that are using that downtime when the portfolio managers are out to prepare for the license. And ASIC has also said to us that if you put your application through and it gets processed very quickly, then they're happy to delay the commencement to closer to the transition period. So it's in their interest as well to get as many applications in as soon as possible to kind of spread that workload. So that's certainly an option if you've got some quieter time coming up to get the project underway and through.
Excellent, Nikki. Now, look, I'm always conscious of trying to be on time. So unless I get an urgent question that I think is relevant at this late minute, I'm going to start to conclude this webinar. Thank you very much for everyone for attending today. And again, the key to this is from Equity Trustees is that we want to try and give you information so that you can do what you want to do, and we can facilitate and help you with things that we are good at versus what you guys need to do. Importantly, this webinar will be recorded, and we will also send you out a link after this session so that you can reread and re-listen to this seminar if you need to. I would very much like to thank EY, but in particular Nikki Bentley, for helping and assisting with this. And Nikki answered all my questions and facilitated excellently. So thank you very much, Nikki.
Pleasure.
And we will continue these updates, so look for them. But without further ado, as they say, I will send you back to BAU. Enjoy the rest of the morning, and just when the vacuum cleaner is starting in the background, one of the funs of working from home, I will conclude today's webinar. Thank you very much, everybody.